So the next topic then is liability of a company in tort and crime. And that goes to the first question we need to ask ourselves, is that even possible? Because the company, of course, isn't a human being, it's not a person. But it interacts with other people, and so we need to think about, in legal terms, does it have a reputation? The answer to that is yes. Does it have a nationality? Well, the question is which law applies to it, and UK registered companies are subject to UK law. There's a different approach to this in continental Europe, but I won't talk about this here. Companies, do they enjoy human rights? To what extent do they enjoy human rights? Some human rights, for example, the right to marry, is not something that can have anything to do with companies. So there's a debate there about to what extent human rights law applies to companies. The liability of companies in tort is easy. It's the principle of vicarious liability applies. The company is liable for a tort committed by an employee in the course of the employee's or agent's employment. So, for example, employees, even if they act against the instructions of the company, as long as they act in the course of their employment, within the scope of their employment, the company is liable. So the two cases here, the Pioneer case and the Rhodes case, they are examples of the company being held liable for a bookkeeper's negligence, and they are for employees who acted in breach of, we're establishing restrictive trading practices. Okay, so here are other examples. Is it the defense that the act is ultra vires? The answer is no. And in Campbell and Paddington, the decision of the governing body was something for which Paddington Corporation was liable. Dubai Aluminum and Salam is I think I said this in the lecture, a kind of a fun case in a way, because this was the case of a solicitor for a modest fee. He participated or helped with fraudulent transactions, which is not what solicitors are supposed to do. And so the company, or rather the partnership in that case, was liable because he acted in the course of his employment. And it didn't matter that he acted against explicit instructions. So that's not part of the test. It's just, is that part of their employment? Now, there's, of course, another question which we just need to remember here, is that sometimes agents have their own liability in tort. So if you take Standard Chartered Bank, in that case, the Pakistani National Shipping Corporation was liable for the fraud, plus the director himself was. So you have two people here liable, one vicariously, Pakistani Shipping Corporation, and the other one in their own capacity as a fraudster. The tricky area here is criminal liability, because the question is, can a company even commit a crime? So there was a time when the answer was no, they can't, because criminal law can quite apply to them. Now we've given that up since, I think, the 1940s. The position has changed. So the question is then, whose acts and intention are ascribed to the company? And here is where the problem starts, or rather the discussion starts. The two cases that are worth looking at is Leonard Shipping and the Bolton and Graham case. In both cases, the idea was the directing mind and will of the company will be attributed to the company. Note that these cases have nothing to do with crime. They're tort cases, or rather, in this case, a sort of statutory liability case. But their directing mind and will test, the test they established, was later moved into criminal law. So here we go. A company can have the intention to deceive a transport manager, and so we see this directing mind and will test now moving into the criminal law area. And in these two cases, then we talk about criminal law. So company can have an intention to deceive through the transport manager who was in charge, but Tesco and Natras was a case where the company wasn't liable under the Trade Description Act because the mistake was made, the misrepresentation, if you like, was made by someone in a subordinate position. That was the case of the shelves being stocked with the wrong washing powder. So the directing mind and will test has the effect that companies are only liable criminally if the basically central authority has the mental element required to establish the crime. So you need to show that the board was intending for something to happen. And that's the directing mind and will test. Meridian and Global Funds says this is a bit more sort of complicated or more subtle, and it depends for statutory crimes on the statutory interpretation. So the first question you need to ask, looking at the statute, is the provision intended to be applied to a company? And then if you say yes to that question, you move on to the second question and ask whose acts, knowledge, or state of mind is for the purposes of the provision intended to count as an act of the company. And that potentially could be very wide indeed. So if you look at how this proposition is stated here, you see that could be anyone. Doesn't matter where in the hierarchy. Now, the St. Regis Paper Company case then takes this back and says, no, it's not quite that broad. So the companies are liable for acts of the directors and senior officers carrying out functions of management or speaking and acting on behalf of the company. So that looks again like a directing mind and will test, albeit somewhat broadly conceived. And they're not liable for acts that are committed by employees who have a particular task. So this also concerned an interpretation of an environmental criminal provision, and the court said, well, the first point of call is the directing mind and will test, that only if that doesn't yield a result that was intended by the legislator will the courts then go further down the ranks. And the same was decided by Vehicle Operator Service Agency and Conway. So the breadth of the Meridian test seems to have been taken back in these two subsequent cases. Meridian was, of course, a Privy Council decision that came out of New Zealand. So where we are here is the default position is a company is criminally liable when the directing mind and will, and you probably can use the broadly defined definition of the St. Regis Paper Company, has the mental element present. Now, the Corporate Manslaughter Act 2007 was designed to remedy a problem. And the problem was at the time or prior to that act, the larger companies invariably escaped criminal liability because you had to show that the directing mind and will had done something wrong. And that's hard to do. And in particular, if that's the test, what the board can do very quickly is delegate all the difficult things far, far down the hierarchy and leave health and safety at the lowest level of the organization so they don't get into trouble. And so that was perceived, that's of course unacceptable. And so the Corporate Manslaughter and Homicide Act 2007 tries to remedy that and says companies are liable for senior managers. criminally. So who are they? They play a significant role in making decisions how a substantial part of the activity is organized, or they manage and organize a substantial part. Note, substantial part of those activities of the company. So that would be, again, fairly high up the hierarchy of that company. Now, here's another model, the organizational failure to prevent model, where under the Bribery Act 2010, a person associated with a company pays a bribe or obtains an advantage to obtain an advantage for the company. That can be anyone, an employee, a supplier, somebody who pays a bribe to get an advantage for the company. And there, it doesn't matter where they are in the hierarchy, but the company is liable, the company is liable criminally unless they can show they had adequate procedures in place to prevent the bribe. So we can see three models for criminal liability. One is the directing mind and will test. The other one is sort of the senior managers, kind of some middle but fairly high up ranking, quite close to the directing mind and will test. And the other one is this organizational failure to prevent model, where liability arises because the company doesn't have adequate procedures preventing that a bribe is paid.